comes the judge. Hear ye him. Oh yeah, God save the African king. Anyone have anything to say before this just judge? Come say it now and say it like a glad, not like a mad. For this judge have no mercy. Or in this time, court's in session. Silence on the court. The court's in session.
The inestimable Peter Tosh taking us into a discussion of appointments to the Supreme Court and balance within the Supreme Court. A rather interesting roll call here, actually. Vasco da Gama and Alexander the so-called Great. Anyway, yeah, Peter Tosh there, apparently one of the big favourites of Douglas Ginsburg, but we'll never really know. So, what we're going to look at here is the process by which we wind up with the Supreme Court Justice. And we've gone over this before, but I think that it merits a little bit of revision, just belt and braces. So, how does it work? Well, vacancies occur more or less at random. This depends upon retirements and death. A president can expect one per term. Generally speaking, that's how it works. Obama, Clinton, Bush 43, they all had two each. Bush 41, Daddy Bush, he had two in a single term, whereas Reagan managed to notch up four. Don't know why. That's just really how it works. And that's the roll of the dice, frankly. But the key thing is to get those appointments right. And we've seen examples where that doesn't happen. But before we worry about that, let's look at the actual process itself. So the nomination is, of course, by the president. There's then hearings in front of the Senate Judicial Committee where they get a weapons-grade grilling from people who should really know what they've been talking about because they've been doing it for a long, long time. That then goes before the entire House for ratification. And that is, of course, a simple majority. Now, remember that because it's important later. So that is about as much as you really need to know about the process. In terms of nominating a justice, we're going to look at the person, and we're going to look at two aspects of the person. We're going to look at experience. Now, somebody really needs to be a fairly experienced judge, a fairly experienced legal practitioner. Something that came up the other day when we were looking at this, Justice Thurgood Marshall, he argued Brown 54. He was an advocate in Brown 54. And he wound up on the court, which is just an interesting little gambit. There are all sorts of nice little bits of evidence you can bring to demonstrate experience. I just quite like that one. I don't know why. Marshall, I think, was the first black justice. We'll have to double check that in class. But there we go. He argued Brown 54 and later wound up on the bench himself. And of course, not just experience, but identity politics. Thurgood Marshall there being a very, very good example. Particularly in the sense in which he was replaced later by Clarence Thomas in 1992. So gender, race and religion, those big three that are going to play a part there. And again, you can see that manifest in the current balance of the Supreme Court. The other things that are going to be relevant is the balance of the court, and the best example of that I can come up with is the fact that Ginsburg is clinging on. She is clinging on at the minute because her position is pretty precarious, certainly in terms of the balance of the court. Were she to leave and were she to be replaced by a conservative, then we'd look at a significant shift in the balance. Again, the real impact of that is going to depend upon the chance of ratification. And there you're looking at the balance between the president and the Congress. Is the Congress going to let this thing through? And Thomas is a fantastic example there, and we'll talk a little bit about Thomas in a little while. The Bush got many things wrong in his administration, but he actually played the Thomas card extraordinarily well in '92 and managed to shift the court significantly, get a very conservative person on in the teeth of Democratic opposition. And we'll see exactly why that was in a short second. So, what does make a contentious appointment? Well, I've just already discussed this. The nominee. Now, Myers in 2005, she was appointed as she was a very, very close personal friend of George Bush. Quite a very experienced White House staffer, very serious and senior in exop. But of course, she had absolutely no bench experience. And then when she was put in front of the Senate Judicial Committee, that lack of bench experience told, and she handled the hearing appallingly badly. And bear in mind that that was a Republican Senate, so she really must have really made a complete and utter whatever of that in order to get such a bad report from the Senate Committee. After that, the Senate Committee reported, we cannot vote for you, and we really very much doubt that the wider House will vote for you, so you may as well withdraw. And she did. Balance of the court, again, we can talk about Ginsburg, the way in which she is clinging on. In the wider political context, we were talking about that earlier. I mentioned Thomas, but before we get to Thomas, let's talk about Bork. He was too conservative for a Democratic Senate, and his appointment would have shifted the balance of the court again. So they were reluctant to do so. That was, of course, a Reagan nominee. Clarence Thomas in 92, he really fits all of those particular Clarences, all of those particular categories. He was a very controversial choice himself. He had allegations of sexual harassment about him. He was going to affect the balance of the court, and he was a conservative judge facing Senate ratification. Sorry, facing ratification from a Democratic Senate. We'll talk about that in a little more detail here, but historically, very few appointments have been challenged. Only 11 have been withdrawn overall. So they rejected. Others have withdrawn or postponed. Bork, we know about. He was to replace a moderate or swing justice. He was considered too conservative. Bear in mind that that was a Democratic Senate there that rejected him. Ginsburg withdrew, having admitted smoking marijuana. Clarence Thomas. Now here we go. So Clarence Thomas was Bush. He was to replace activist progressive Thomas Thurgood Marshall, but he was thought too conservative. There were also those allegations of sexual harassment. However, the Democratic majority in the Senate at the time was in a bit of a bind. Clarence Thomas was very, very conservative, but he was also very, very black. And as a result of that, he was in a position to lay one off against the other. So the Democrats in the Senate were in a bit of a bind. They were faced with a race card and a conservative card, and in the end, they went with quality. I mean, Clarence Thomas is very, very conservative. He's also very, very clever, and they decided to go with him. And we can perhaps talk about that in class. The Senate endorsed him 52 to 48, in spite of the fact that the Senate was a 56 majority to the Democrats. So very, very interesting little episode there with Clarence Thomas. Harriet Miers, we talked about her earlier. She was to replace the swing Justice O'Connor. I should correct that really. But having never previously served as a judge, she was basically mullered in the Senate. In the Senate committee hearings, and they said, look, don't even bother coming along for the ratification because it's just not going to happen. She was replaced by a very conservative, very able Alito, and of course he's still there. Here's the Roberts Court for you. Worth knowing who appointed who and when, and of course all eyes on Ginsburg. All eyes on Ginsburg as being the next one to go. And yeah, very, very interesting. She is clinging on because, of course, she knows that were she to retire at the moment, the chances of her being ratified by a Republican Senate or the chances, sorry, of a Democratic replacement being ratified by a Republican Senate are virtually negligible. And as a result, she's clinging on in the hope that well, something better will come along next time, certainly in the hope that a Democrat will be returned to the White House after Obama. Judicial neutrality, well, we talked about the balance of the court there, and we can see that it's very finely poised at the moment. Technically in the balance with 4-4-1, but we know that Kennedy will tend to swing conservative in most matters, but liberal, perhaps progressive in matters of sexual orientation. So Kennedy, an interesting person. The next appointment is going to be material. It will have an impact on the balance of the court if Ginsburg is replaced by a conservative. That will have a profound shift profound effect on the balance of the court. And you've seen this slide before. It's really just another little summary. And I'm going to leave you with that. I'm going to leave you with a bit more Peter Tosh. And I'm going to be around in class to answer those questions as and when they come up. So that's it from me for now. Any questions, you know where to find me. I look forward to talking to you and raising those issues as and when they come up. See you in class.
Court's in session, silence in the court. The court's in session, silence in the court. The court's in session, silence in the court.